Parliamentary sovereignty. Parliamentary law is supreme in England and Wales over other types of rule. It ensures that any tradition, legal practice, existing law, or Parliament's prior act can be absolutely overruled by a Parliament Act. This is also alluded to as the dominance of Parliament. The principle of parliamentary sovereignty is based on the idea of representative governance. In the constituency, a member of Parliament is chosen by the people, so that in principle, on account of those constituents, the MP takes part in the legislative process. This view, though, is very simplified since MPs generally vote on party lines instead of as their voters desire. Most MPs are chosen by a very narrow majority, and if there were many contestants in the election, it would seem that only about 30% or even less of the citizens actually voted for the MP. Parliamentary elections only have to be conducted once every 5 years in order not to automatically remove an MP who votes against the interests of his constituents. Furthermore, the basic idea of democracy lacks because much of the legislative drafting is performed by non-elected civil servants. Finally, the argument is that the House of Lords is not an elected body. Should be the first thing you write in your paper. Definition of parliamentary supremacy. In the 19th century, Dicey provided the most commonly accepted concept of parliamentary supremacy. 3 main points he made. Parliament may legislate on any subject. No parliament can be bound by any prior parliament, and no parliament can pass any law that binds a later parliament. No other party is allowed to circumvent or set aside a legislative act. Legislating on any subject matter. There are no restrictions on what laws can be made by Parliament. It can make whatever law it wants. Parliament has changed the policy on who should achieve success to the throne, for instance, in the past. That was in 1700 after Parliament enacted the Settlement Act specifying this King James II's offspring, who were the monarchy's direct line, could not ascend to the throne. Parliament will alter its own forces as well. This did so with the 1911 and 1949 Parliament amendments, which imposed restrictions on the House of Lords' power to block a bill by voting against it. Cannot bind the successor. Any new Parliament must be free to make or amend the laws it needs. Parliament cannot be bound by an earlier parliamentary law and can repeal any earlier parliamentary act. Nevertheless, there are some rules that have become such an integral part of the British system that they cannot be removed in a realistic way. The Settlement Act, for example, altered the line of succession to the throne in 1700. It influenced who had the privilege to be king or queen. Practically speaking, this cannot be abolished now after 300 years. There are other new limitations that Parliament has self-imposed. Cannot be overruled by others. The provision remains preserved even if Parliament's statute could have been repealed due to incorrect knowledge. British Railways Board v. Picken, 1974, illustrated this. Parliament passed a secret legislative measure, the British Railways Measure of 1968. Picken challenged the act on the grounds that Parliament had been fraudulently covered up by the British Railways Board. This alleged fraud has driven Parliament to enact the act that stripped Picken of his land or property rights. The case was thrown out because after it was enacted, no judge is allowed to go after a statute. An act of Parliament cannot be contested even if bribery has happened. Limitations on parliamentary sovereignty. There are now certain limits on the parliamentary sovereignty, but prior parliaments have self-imposed all these restrictions. The key restrictions are: membership of the European Union, the effect of the Human Rights Act 1998, membership of the European Union. In 1973, the UK entered the European Union. Parliament adopted the 1972 European Communities Act to become a participant. While it is possible in theory for a later Parliament to pass a law turning away from the European Union as the Parliament passed that act, political reality means that this is highly unlikely. EU membership influences our legislation and political system to a great extent. Such as the HRA 1998, which requires the Parliament to read the UK law in line with the EU law. EU membership means that EU legislation takes precedence over English law even where English law has been passed in accordance with relevant EU legislation. This was illustrated by the 1988 Merchant Shipping Act, which defined regulations for who could own or control UK-registered fishing boats. The Act stated that 75% of managers and shareholders must be British. The European Court of Justice found that this was contradictory to EU law, which allows citizens of all member states to operate in the other member states. As far as other EU citizens were affected, the 1988 Merchant Shipping Act could not be successful. Human Rights Act of 1998. It notes that all Parliament's activities must be consistent with the European Human Rights Convention. Legislation can be questioned on the basis that it is not in compliance with the Convention. The courts have the authority to declare an act inconsistent with the Convention under S.4 of the Human Rights Act. The first incompatibility argument was in H.V. Mental Health Review Tribunal, 2001, where an individual asked for parole. The 1983 Mental Health Act put the patient's burden of proof to prove that he should be published. Human rights indicated that defending the prolonged treatment of such an individual should be up to the state. The court made a statement that human rights were not compatible with the law. The government changed the law after this announcement of incompatibility. A statement of incompatibility does not, therefore, means that the government will amend the law. When Parliament wants, it will also be able to pass a new act that violates the European Convention on Human Rights.